Okay, guys. So I have the this is how it came through, guys. So I don't know what we about to see, how we about to see this stuff. All I know is in my mental mind, this news station and how they did this kind of like then took me for a number. And I do mean a number. But without that being said, let's go ahead and see what we have. I'm not sure what you mean you can't see. You can't see now? I don't know. I don't know what she's talking about. Um, so I apologize for anybody that was here. I kind of had it set up because I thought that they were going to show us jury. I thought they was going to show us some jury stuff, right? And it's so crazy because of course they didn't. So that there's that. Yeah, so that's what we working with here. So I apologize for all the whatever. But let's go ahead and do this, and then we'll go back to our other trial that we're working with now. Okay, so here we go. Yeah, because I would like to do like a verdict watch and listen to jury instructions. We got none of that shit. So there's that. This is how they did it. Look at this mess. Let me show y'all this mess. Wait a minute. I gotta find the screen. Here we go. This is how they did it.
And guilty of killing two of his family members with a hammer. It happened within the last 15 minutes. That verdict, they found him guilty on 2 counts of first-degree murder. The jury began deliberations this morning, about 3 hours ago. Yesterday, for the first time, we heard from Jordan Allen, who took the stand to be cross-examined for his role.
Yeah. What the fuck? Yeah. That's right. That's exactly how they did it. Breaking news. And that's how they did it. That's exactly how they did it. I was so mad when I seen that today. I couldn't believe it. I couldn't believe it. So the reason why I know that I needed to set up a room for this is that he's guilty is because they're into sentencing now. So I'm gonna take us into the sentencing hearing now. It's such bull. So he was found guilty. It only took 3 hours, and yeah, that was it. Just guilty, real quick. That's how I came through. Like no build up, no nothing. Just hey, they deliberated for 3 hours. He guilty. I know. It was such a bummer. I'm like, dang, they didn't even let us see jury instructions. They didn't let us see anything. I've never seen anything come through like this, but this. And I guess this is the problem when you're working with local stations because I guess they do not just sit there waiting. So this is literally how it came through.
A Greene County man guilty of killing two of his family. Look. Breaking into our newsroom within the last few minutes, a jury has found a Greene County man guilty of killing two of his family members with a hammer. It happened within the last 15 minutes. That verdict, they found him guilty on 2 counts of first-degree murder. The jury began deliberations this morning, about 3 hours ago. Yesterday, for the first time, we heard from Jordan Allen, who took.
Yeah, they did it as breaking news. And that no, you didn't get no foreplay, you didn't get nothing. No. They said they ain't even gonna give you no Vaseline, they're just gonna stick it on you. There you go. 3 hours? I thought this jury would have been out for way longer. Yeah, I thought way longer, but let's go into it because not only did they do that, they went right into sentencing, y'all. So let's go in and let's go watch the sentencing. At least we can watch that. They are still that's not over with, so we can watch that. Okay, guys. So let's go into that part and watch the sentencing. Like they about piss me off with this whole mess. They're gonna show the entire trial, except for the opening statements. I gave them a pass on that. Show us the entire trial. Then we get to the end where where things are important and they didn't even send out an alert. They didn't send nothing. They just said, here you go, figure it out. So let me get that part up for us. I'm going to share. I am going to make big, and here we go. Let's go in here.
He needs, the victim needs to write, not right now. I'm gonna need to know what he's gonna write out. He's gonna write it out and read it. He can't get up here and just start talking and stuff. It's gotta be something, I've gotta control what's being said. That's what the law says.
We've had that discussion.
It's gotta be how it affected him.
Yes, sir.
Not Mama or somebody else, how it affected him. He's the victim being, it's gonna be the deputy, correct? Williams, how it affected him by losing his sister and great nephew.
Sir, he did ask one question about him. He talked about how it affected him as it relates to his immediate family, his wife, his kids.
If it affect how it has to be about how it affected him, not how it affects them. It's the victim's impact. Here's how it affected him. So, and he's got to write it out, and I've got to look at it, read it, and then that's what he's going to read to the jury. So I've got to kind of control it. Can't just get up there and just start going on some narrative. That's what the law requires. So, but that only comes in after there's proof of aggravating circumstances.
Yes, sir.
So, clear on all this? Everybody clear on all this? You need a few minutes to talk to him?
I'm just,
I'm gonna let you go talk to him. I'll take a brief recess. This is unusual. It's just something, it doesn't happen very often. Once every several years.
all right.
All right. So we'll take a brief recess. You talk to your people, and then we'll come back to start this thing.
We're being recessed.
Because killing a witness to one murder, and there's two people dead here, killing one person to keep them from being able to say what they saw, the murder that they witnessed. So a witness was killed, either Cherry Cole or Jesse Allen. One of them was a witness to the murder. There was one killed first. And when the second person was killed, they did away with the witness. So that could there's evidence, and the jury can determine this or not, that would avoid, interfere with, or prevent a lawful arrest of somebody when you kill a witness. So that's just something that a jury, I think there's enough evidence there by the proof in the case, and I'll let the jury determine whether that applies or not, and the state can argue that. So if the jury determine that. All right, are we ready?
State's ready, Your Honor.
State's ready. Is the defense ready?
Yes, Your Honor.
All right. Is the defendant going to testify at this hearing?
No, Your Honor.
Okay, would you please raise your right hand, be sworn? You solemnly swear affirm testimony you give me the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Asking the moment questions for this hearing.
Jordan, do you understand you have a constitutional right to testify in your own defense? Do you understand that no one, including myself, the prosecutor, or the judge, can take that right away from you?
Yes, sir.
Do you understand that you also have an absolute constitutional right not to testify and to remain silent? You testified earlier in this case, correct? Okay, so you've been through this before. You understand what rights you're giving up? And do you understand that the choice of whether to testify or remain silent belongs entirely to you? And have you made the decision regarding whether or not you want to testify today?
I didn't hear him.
I do not.
Good, I do not want to testify. All right, well, bring the jury in.
All right.
Are there going to be any new witnesses to testify?
Yes.
Okay, we'll need to swear them when the jury is in there. All right, thank you. Be seated. I'll let the record reflect all the jurors seated in the box, defendant present with his counsel, and it's time for the bifurcated hearing to start. And is there going to be any opening statements by the state?
Judge, we'll put on an open statement, but we're not gonna put on any proof. We'll rest on the proof that was presented at trial.
Okay, you have an opening statement as to the aggravating circumstances.
I do, Your Honor.
Okay, you want to talk about that to the jury in
It's
open
very
statement?
brief. It's very brief.
Okay.
Members of the jury, I'm gonna be super brief. Excuse me, I'm sorry. I promise I'm gonna be super brief. It's been a long week. But we're not at the end of the road just yet. Like I said, we're not gonna put on any proof. We're gonna ask that you remember everything that you heard and saw this week. The state of Tennessee has asked you to consider life without the possibility of parole. We have to prove at least one of two provisions. Judge is gonna instruct.
Called
you.
aggravating circumstances.
Excuse me.
That's the
At least one of two
operative
aggravating
term.
circumstances. We have to prove first, or we have to prove either of these. That it was especially heinous, atrocious, or cruel, in that it involved torture or serious physical abuse beyond that necessary to produce death. And two, and again, we have to prove either one of these, that the murder was committed for the purpose of avoiding or interfering with or preventing a lawful arrest or prosecution of the defendant. Those are the only two aggravators that we are asking you to consider. I just ask you to remember the testimony, remember what you saw, what you heard. As you're going through this, you heard the pathologist say that any of these blows to the head would have been necessary to produce death. So when you look at this and you're considering what you've heard, serious physical abuse beyond that necessary to produce death. Think about the first blow. He said he hit him 5 times. I'll do it on the downside. He may have said 5 or 6. I have to go back and look. That's for you to decide. It's pretty obvious from those pictures that he just, both of them was the same way. As far as the second one goes, they did it to prevent getting, basically, did it so he wouldn't get caught, so he wouldn't get in trouble. If you believe, look, I don't know what you base your decision on, but if you put any stock in what Mr. Hale said, you heard what he said. That Jesse saw him kill him out, he didn't have a choice. But they told law enforcement that he killed Jesse first. Malon come out and saw it. Just please consider what you've heard, what you've seen, and we're going to rely on all of that and ask you to find that, actually both of these do apply, but we're going to ask that you give Mr. Allen, give him the same mercy he gave his mouth. Life without the possibility of parole.
All right. It's going to be time for the state to put on their proof, which includes a statement that I've got to read in advance. So right now, for the opening statement, I'm going to let the defense do their opening, and then we're going to take a break again to give me that statement to read. Who's going to give it first? Ms. Dalphy, you going to do this?
Yes, sir.
This is Leslie Dalphy, Assistant Public Defender.
We are all better than the worst thing that we've done. We all have more to give than the worst thing we've done or the worst day we've experienced. I spent almost 20 years advocating for children who were abused and neglected in juvenile court because I love children. The interesting thing is, I didn't realize I'd be doing the same thing in criminal court, but that's what I'm doing because Jordan Allen has been an abused and neglected child his entire life. You know, if you look down at scars that we have, you can see them and you can remember what caused them. Sometimes it might have been happy, you know. My grandfather told me not to go down the hill so fast on a bike, but it was fun when I did it, and that scar is happy. Other times you can look at it and, you know, maybe it's something that produces a bad memory. But the difference between those scars and the ones I'm going to talk about with Jordan is that you can't see his. Every person who was ever supposed to protect him has utterly failed him in every way. We've spent several days. You've listened to the state talk about the evidence, and you've listened to the defense refute that evidence. But I want to tell you about the person that Jordan Allen is. I want to tell you about the crime that he's been convicted of. I want to remind you, you can't see his scars. You can't touch them. They're not tangible. But they have profoundly impacted him and the way that he lives his life and lives day to day. He lives with those and the weight of those. There'll be a series of witnesses that you will hear from. You'll hear from a professional. I hope to put on a friend of Jordan's. You'll hear from a former principal. Now I'll tell you things about Jordan that I already know. The reason I know those is because I've spent, I'm not supposed to get emotional, I'm really sorry. I've spent a year and a half getting to know him, and there are kind parts to him, and he's considerate, and he's funny, and he's respectful. So I tell you all of that in hopes that you can see Jordan, just a glimpse of what I see in Jordan. I'm hopeful that you will be able to consider all of the testimony that we're going to put on and just judge him for who he is, not the worst thing that he's done in his life. You know, I'm very saddened to think of throwing a life away, which is kind of what we do if someone is sentenced to life in prison without parole. So I'm challenging you guys with a new task, one that's difficult, just like it's been for you all week, to look past what you found him guilty of, look past what he's done, and see who he is and why he is that way. Give him an opportunity to have a life outside of prison walls. Give him an opportunity to show that his life can be something. Sadly, if you give him that opportunity, you may be the first person to ever give that to him, the first person to ever give him a chance. I'm hopeful that you will give him the chance that I know he deserves. You can sentence him to life without parole, or you can give him that chance today. We are way past retribution. You found him guilty. He's going to serve a lengthy sentence. He's been convicted of this crime. I'm just asking you to see the human side of Jordan and really see that there is somebody there who could be productive, somebody who's capable of rehabilitation. Thank you, and I'm sorry to cry on you.
Take the jury out.
All rise.
Okay. You see, all right. Have you come up with a victim's impact statement?
You check.
It's gonna be one, right?
Yes, Your Honor. First one I had it written out, he didn't realize he had the handwriting.
read that. I'll let the defense read it too, if they want to read it. We probably need to make that an exhibit. Let me make that written copy of the exhibit. He'll get it back to read it, but I need it to read it. Are we at 5:15?
Yes.
5:15, victim's impact statement. Now, before he reads the victim's impact statement, the state has to, you have to get up and put on proof of the aggravated circumstances, how you're gonna do that, by the evidence, or how you're gonna say you're gonna do that. Then that's read, and then you rest. You don't put on victim's impact statement until, we're opening up the proof. It's just like the proof's gonna be open. So the proof's in the record, but you've got to tell the jury about it. So 5:15 is the Rick Williams victim impact statement.
Doesn't record what they go into detail or just.
Well, that's up to you. I mean, you can remind them of certain evidence or however you want to do it. The evidence in the record, but you got to put on some kind of, it's a safe time to put on proof, and there's proof in the record, but then it's something, and there has to be proof of aggravated circumstances before the victim's impact statement's read. And then at some point, I'll say anything else, and you'll rest, just like a regular hearing. You'll rest, and then it'll be time for them to, and they'll have to swear their witnesses.
I'm sorry, like the court said, we haven't done one even long.
It's been a while, but there's not, I mean,
Thank you, Your Honor.
are we ready? Anything else? Bring them back in.
All right.
All right, thank you, B.C. Let the record reflect all the jurors sitting in the box, present with his counsel, and it's time for the state to introduce their proof.
Thank you, Your Honor, and may it please the court. The state is choosing to rely only on the testimony and the evidence that you have, that you've heard and seen. As I mentioned very briefly just a minute ago, especially heinous, atrocious, cruel, and that it involved serious physical abuse beyond that necessary to produce death. If you have to look at all the pictures again, I do believe you'll have those, since we're relying on the record. I'd like to incorporate all that evidence into this hearing.
They had the exhibit, look in the jury room.
Thank you, Your Honor. So each and every one of those, look, all very smart people. Look at those pictures, at what he did, at what he done. All those injuries on the back of the neck that they received, you heard the pathologist talk about, most of those were inflicted after death. And any one of those injuries to the head would have been fatal. And on both of them, would ask you to focus on that. Would ask you to focus on the testimony that you heard about the, about the order of their deaths. Certainly didn't kill them both at the same time. He killed the witness. And he told two different things about the order and why. So just going to rest, not going to put on any more witnesses or any more proof. We're just going to ask you to consider the facts you've already, we do have a victim impact statement. We're going to present Rick Williams, and he's going to talk about the effect these murders have had on him. And Judge, we'd like to do that at this time.
Come on up, Mr. Williams. Come up here to the podium. I'll just let you do it from the podium. I'm gonna swear you again. Raise your right hand. You solemnly swear from testimony give me the truth, the whole truth, nothing but the truth, so you got.
I do.
Well, if you'll get up there, I read his statement. He's gonna read his victim's impact statement. Go ahead.
First of all, I'd like to thank the members of the jury. I know what a weight this is for you all this last week. I've carried it for the last 4 years. I will carry the images from that night with me for the rest of my life. Those images, those events have forever changed my life. But I refuse to let Jordan Allen continue to take anything else from me. We all know what he has taken from me. He will not take anything else. When asked, are you having a bad day? The answer is always no. I've had a bad day in my life. Just I, and we all know what day that was. I know no one wants to think a 16-year-old could do this, but it happened. And here we are. I ask you all to give him the maximum sentence with no parole. Thank you.
Thank you. Give that back to the court order. Yeah. Thank you. Anything else from the state?
Judge, respectfully,
State rest. For the defendant, you have witnesses. Do I need to swear?
Yes, sir.
Bring your witnesses in. Witness? They're here? How many witnesses we gonna swear?
Well, I hope to swear forward, but
Okay, all right. One, two, three. Is there another one?
no, sir.
We have three. All right, raise your right hand and be sworn. Solemnly swear affirm the testimony you give be the truth, the whole truth, and nothing but the truth, so help you God. These are all requested. Stay
yes,
with
Your
you.
Honor.
All right. Step outside. We'll call you one at a time. Which one are you gonna call first?
Jessica Ricker.
Jessica? We're calling you first.
Ms. Jessica, will you state your name for me, please?
Jessica Ricker,
Where do you work?
the Greene County Detention Center,
And what is your position there?
the administrative assistant.
As part of that position, do you keep track of programs that inmates are allowed to do?
Some of them,
Are there educational programs available?
yes,
Are there vocational or counseling programs or classes available?
I mean, we have like the educational tablets that the inmates can get, and I have those right here. He has about over probably 20 certificates.
Okay,
And the administrator, John Key, said he did receive his diploma while he was incarcerated, but we did not have a copy of that.
okay. I've got a copy of some things. If I could have you to look at them, if you
Okay.
wouldn't mind.
Okay.
Do you want-
Yeah, yes, that looks about similar to what I have in here.
Okay, are those certificates that come from classes that are done on the tablets?
Yes.
Okay,
And I also have two that the state actually brought like 2 days ago,
okay,
where he was in a pilot program.
okay,
It was it's a more advanced class that inmates were able to attend on the tablet. And then once they completed, the state actually gave them a certificate that's sealed with a sealed with a.
Do you have those with you?
Yes.
Okay. Could we include those in the documents that I gave you?
Yes.
Are those true and accurate reflections of what the certificates look like, what's issued?
Yes.
Okay. Would you make that an exhibit to your
I'll
testimony?
make all of them a
Yes.
collective exhibit.
Yes.
All right, collective exhibit 516. There's more than one, right?
There's over 20.
There's 22.
Green County Sheriff's Department certificates. Gordon Allen.
And Judge, could we publish that to the jury?
Yeah, I'll publish it to the jury.
Thank you.
She got stamped first.
Yes, sir. Ms. Jessica, are these classes mandatory for the inmates to enroll in and complete?
No.
Okay, so completely voluntary and by choice, is that right?
Yes.
And I think you counted, what'd you say, 20 or 22?
I think it's a
certificates you
little
had?
over 20. I'm not exactly
Okay,
sure on that number.
and would you say that they cover self-improvement? Did he do any self-improvement classes?
I'm not sure.
Okay, that's all right if you're not. Did he do any vocational things, if he covered those?
I'm not sure.
You're not sure. The certificates just speak for themselves, is that right?
Yes.
Okay. I'm gonna show you something else, if you don't mind. Now, I believe you're gonna be able to tell what this is. You tell me what that is a copy of,
High school diploma.
and whose high school diploma is that?
Jordan Allen.
Jordan Allen. He was incarcerated before he finished high school, is that accurate?
Yes.
Okay, so did he complete the requirements for a diploma while he was incarcerated?
Yes.
Okay. Judge, could I,
Let it be filed as 517.
thank you.
Is that like a GED? or
It's
is it-
an actual diploma, Judge.
Okay.
Mhm. Ms. Jessica, I'm gonna show you something else here. You could just tell me what you're looking at. I've handed you a certified copy from the clerk. Can you tell what that is? Does that appear to be
His charges.
Yes, does it appear to be Jordan Allen's criminal record?
I'm not sure.
Okay, that's all right.
What is it?
It's a certified copy from the clerk, Judge, that shows he didn't have any charges other than these.
Okay, all right. You want to file that?
That's fine.
All right, certified copy, no criminal record, 518.
Yes, sir. Ms. Jessica, have any further questions?
Thank you.
For calling, fine.
Oh,
I'm sorry, ma'am, just nothing. Y'all give everyone a chance to finish their education, is that fair to say? Especially kids.
yes.
You gave that to Mr. Allen, and we're all thankful he took advantage of that, right?
Yes.
It's all online or on the tablets, right?
For the
To finish his education.
Oh, now the diploma, I'm not sure. I'm not sure how he finished that. I'm not sure how.
Whether he interacted with anybody, you don't know if it's
No.
all online on the tablet or what. Thank you,
No.
ma'am.
Anything else from her? She's free to go? You're free to go back to work. Call your next witness,
Dr. Catherine Smith.
Dr. Catherine Smith. step right there. Come up here and sit down and get comfortable and speak up so we can hear you.
Thank you.
Dr. Smith, would you state your name, please?
Catherine, Kathryn, Ray, Rea, Smith, Smith.
What is your occupation, Dr. Smith?
I am a forensic psychologist in private practice in Knox County.
What is your educational background?
I have an undergraduate degree in psychology from the University of Tennessee. I have a doctorate in counseling psychology also from the University of Tennessee.
After you received your doctorate, did you obtain any licensure?
Yes, I'm licensed as a psychologist in Tennessee. I've been fully licensed since 1999.
Are you a member of any organizations with forensic psychology?
Yes, I'm a fellow with the American Academy of Forensic Psychology.
Do you have any certifications?
I'm a certified forensic examiner in Tennessee by the Tennessee Department of Mental Health and Substance Abuse Services, which enables me to work as a court-ordered mental evaluator.
Are you board certified?
I'm board certified in forensic psychology by the American Board of Professional Psychology.
Since obtaining your licensure, how long have you practiced?
27 years.
And what are your primary areas of practice?
I'm a full-time forensic psychologist at this point in my career. I have had a therapy practice in the past, but since 2012, full-time forensic psychology.
Can you tell me, okay, tell the jury too, but tell me. Can you tell me what a forensic psychologist is?
A forensic psychologist answers questions applying psychological knowledge for lawyers and courts.
What type of evaluations are within your scope as a forensic psychologist?
I primarily do work in criminal and juvenile court contexts. And I also do some civil court matters. So I do a variety of evaluations. For instance, in juvenile court, I conduct competency evaluations. I do evaluations for transfer cases. I do diagnostic evaluations, dispositional evaluations to see what kind of treatment is needed. I do risk assessments. And then in the criminal court setting, I do competency to stand trial, mental state at the time of the offense to see if there's support for insanity, Miranda waiver evaluations, false confession or disputed confession analysis, sentencing mitigation in juvenile and criminal court settings. And then in civil court settings, I do fitness for duty evaluations of police officers, fitness to practice evaluations of doctors and dentists. I do evaluation for conservatorship and to see if people meet criteria for commitment to a psychiatric hospital.
Do you have any academic appointments?
Yes, I'm a clinical assistant professor with the University of Tennessee.
And what is your role and what functions do you perform in that capacity?
I supervise graduate students who do evaluations in juvenile court. They evaluate youth and parents for diagnosis and treatment recommendations.
Have you written any treatises or are you a published author?
Yes, quite recently, I co-authored a chapter on youth or evaluations of youth who confess or enter guilty pleas. And it was in a book on confessions and guilty pleas of youth that was published by the American Psychological Association this year.
Do you have an estimate of how many hearings you have testified in as a forensic psychologist?
60, that's actually exact number. So today is the 61st time.
How many times have you performed evaluations as a forensic psychologist?
I have done more than 800 evaluations as a court-ordered evaluator in Knox County, and a conservative estimate of evaluations that I've done for defense attorneys is 800. And then I've worked on 8 cases for the state.
Have you performed any, I think you just answered this, but I want to make sure I understood. You have performed for both the state and the defense.
Yes,
Okay. And you have done evaluations for both the state and the defense previously.
yes.
Okay. I'm going to pass you something up, Dr. Smith, if you could just, thank you, Mike. You could identify that for me, please.
This is my curriculum vitae.
And would you make that an exhibit to your testimony?
Yes.
Thank you.
Filed exhibit 519.
Your Honor, at this time, I tender Dr. Smith as an expert in forensic psychology.
Let me testify.
Thank you. Dr. Smith, have you had the opportunity to evaluate Jordan Allen?
Yes.
What, or was your first contact to evaluate Jordan for a transfer hearing?
Yes, in September of 2022.
Okay. And so that was after he was incarcerated, is that correct?
Yes, he was in juvenile detention.
Did you see Jordan at any other time during his incarceration?
No, not well. Yes, in February of this year.
And what was the purpose of that visit with Jordan?
To just update my findings and just gather data on whether he has the potential to be rehabilitated.
Okay. So just so everybody understands, because it's a little muddy, can you tell us what you do for the transfer hearing and versus what you do when you're just evaluating for rehabilitation and how those differ?
Well, the method is pretty similar overall. I mean, in terms of conducting a psychological evaluation, reviewing relevant records, conducting testing that is relevant, doing a clinical interview, integrating the information, and writing a report. For a transfer evaluation, when I conducted the evaluation for Mr. Allen, I was looking at just looking at his psychological functioning. Did he have any issues? His background, his level of intelligence, his prior delinquency record, any services or programs or treatment he had received. And I was looking at whether he needed treatment and whether he's likely to benefit from treatment if he gets it. And in that context, it would have been programs and services available through the juvenile court. I was also looking at risk for future dangerousness.
Let's talk about that a little bit, okay? Because you evaluated him for the transfer hearing.
I did.
And please tell us what your findings were there and what your recommendations were.
I found that Mr. Allen had a depressive disorder. He had a history of ADHD. He met criteria for oppositional defiant disorder. He had a documented history of trauma and adverse childhood experiences, and he had a cannabis or marijuana use disorder. And I recommended that he receive counseling, therapy to address his depression, his trauma history, that he be considered for medication, that he have assistance with his education to make sure that he stayed on track in meeting his educational goals.
To your knowledge, Dr. Smith, did Jordan receive any counseling since you made that recommendation?
Yes.
And I believe it was for trauma what was it, trauma-based or cognitive trauma-based counseling? Is that right?
For the past 3 years, Jordan has met voluntarily with Lindsay Holt, who's a forensic social worker with the Public Defender's Office. And she has helped him work on a number of issues. She's worked with him on education, teaching him about emotions and about how the brain works, teaching him skills, communication skills, setting boundaries, regulating himself when he gets distressed. She has helped him process grief and shame. And then she's done some tentative work in terms of processing trauma, but that has to be handled carefully in the jail setting because it's not a therapeutic environment or a treatment setting. So it's not a good idea to open people up to all those feelings and then leave them to go back into the jail. But yeah, he's done this completely voluntarily. And he said he's benefited from it. And I think he has as well.
The purpose of your second evaluation was to assess Jordan for rehabilitation. Is that correct?
Yes.
Okay, so if you could, you've told us what you recommended at the transfer hearing. Could you tell us what the findings of your second assessment were as it relates to rehabilitation?
Yes. So my second evaluation, I looked again at his psychological functioning because it was 3 years and 8 months since I had done my first evaluation. And based on the testing that I did, he had changed. He was no longer dealing with a depressive disorder. I think that had improved with the therapy that he had. He did have some anxiety. I diagnosed him with generalized anxiety disorder, which is chronic worry and tension. He still has unresolved trauma that he's affected by. He's been in a controlled environment since he was 16, so he hasn't used substances in that length of time. He outgrew his oppositional defiant disorder. So he's really, I think, in many ways doing better. He was more mature this time when I saw him.
It's fair to say that Jordan followed your recommendations from your assessment for the transfer hearing. Is that correct? As far as what he could do?
Yes. So he took advantage of the counseling and therapy that he had. And he voluntarily completed his high school diploma. He has voluntarily completed additional educational programs available to inmates in the jail. And he has worked on improving his physical self by exercising regularly in the jail. And he has resumed communication with his mother.
As part of the documents that you reviewed and that you received to help you assess Jordan, did you review records from the Department of Children's Services?
Yes.
Is it fair to say that there was about a 7-month case, sometime began around October, November of 2021?
Yes, that wasn't his first case.
Yes.
But yes, that was, I think it was August of 2021.
It's interesting that you said that wasn't his first, Dr. Smith. Will you tell us how many he had, and do you recall what they were for?
There were 3 DCS investigation reports that I reviewed. The first was from 2014, and it was a referral for a drug-exposed child. And the second one was in 2015, and that was for, I remember the context. I can't remember exactly what the referral was. But yeah, I remember those cases. I can tell you more about them if you need me to.
I don't know about if there are any pertinent details that you want to share. I think that's fine, but could you tell us what impact that had on you, why those are significant?
Say that again, what?
Could you tell us why the episodes of DCS are significant, in your opinion?
The 2014 evaluation was significant because it documented that when he was 8 years old and had been living with his grandparents because his parents split up when he was 6, and he was living with his mother and her boyfriend, and they were using and selling drugs out of the home. When the DCS investigation occurred, Jordan was, or Mr. Allen, I'm not sure how I'm supposed to address him here, but he was interviewed and he was extremely knowledgeable about the drug activities that were going on in the house. So he knew where the drugs were kept. They were under his bed. He had seen people coming in and out of the house to buy drugs. He'd seen people with needles in their arms. He had been told not to touch the black box that was under his bed, and he referenced his mother's boyfriend's machete. And there was violence in the home between his mother and her boyfriend. So he was removed from that house, and his mother ended up going to prison. So really the last time he saw her was when he was 8. And then the 2015 evaluation, he was placed with his father and his father's girlfriend and her children. And his father had an incident in which he got really drunk and vandalized his girlfriend's car and threatened to burn the house. And so DCS got involved then, and there were some interventions to get the father to address his alcohol problem, which was significant at the time. They were told to not have alcohol in the house. And when they talked to Jordan as part of the investigation, he talked about being really scared and crying because his dad was crazy.
Dr. Smith, what did the investigation over the 7-month period in 2021 cover? Do you recall?
Yes, that was for DCS had received a report of abandonment that his father had taken him to his grandparents' house 3 years earlier and left him there and never came back to get him.
So during those 7 months, was it ever recommended or required for Jordan to undergo any clinical or clinically based treatment?
No, the services he received then were a case management model, some family sessions, and he did have some sessions just with a worker, but they weren't private or confidential. They occurred at the school, and there was always somebody from the school sitting in.
Is it fair to say that what would have been appropriate is for the Department of Children's Services to have considered the trauma from his past and offered assistance on that during that 7-month investigation?
Yes. It confused me why they didn't correlate the different evaluations or investigations. They didn't look at what had happened to him earlier and what was going on now. And they really didn't explore in any kind of below the surface way what was going on with him at the time that they got involved. There were no trauma screens. I mean, that's a really easy thing to do, but they didn't do a trauma screen. They certainly didn't do any diagnostic workup. They didn't diagnose him with anything.
What were the primary sources of information during that investigation that they used?
It was minimal. They looked at the house where he was living, and they talked to his grandparents and him and his brother. And I think they got some information from the school about his functioning at school.
In your opinion, would it have been appropriate to have interviewed neighbors, teachers, friends, anyone outside of the home?
I think that would have been helpful to get just a bigger picture, especially with the prior DCS investigations.
It's safe to say that that DCS investigation just relied solely on what was told to them from members inside that household. Is that right? Is that what you're
Yes.
saying? Okay. Did Jordan ever participate in any private individual counseling during that time?
No, he never had any of that prior to his arrest.
He never had a clinical evaluation, I think you said. Is that correct?
Not until after his arrest.
You mentioned before that there were some conversations that were had at his school, but they were not private. Do you have an expert opinion on how individuals feel? Are they freer to disclose or less likely to in private versus if someone else is sitting in there?
Yes, so therapy works because of privacy and confidentiality. When you go in to see a therapist, you know that you're just talking to the therapist, and you can be freer to open up about your real concerns, to be honest. And you've got somebody who is expert in helping to elicit information about the past.
Do you believe that Jordan would have benefited from private one-on-one counseling if the department had done that at that point in time?
Yes, based on what I saw when I evaluated him after his arrest, and I should mention that he was also evaluated by a psychologist at the mental health center after his arrest, and they also identified different conditions and made recommendations for very similar interventions that I recommended. Yes.
I think it's safe to say, okay, tell me if this is the right conclusion. Are you saying that DCS failed to elicit all of the information they should have gathered?
Yes, I think they missed the boat in terms of his issues and concerns and his history and risk factors.
And would that have been something that would have been beneficial to assist Jordan and perhaps really offer him rehabilitation?
I think it would have been a great thing for him.
I think you told us how much time passed between the two assessments. What was it?
3 years and 8 months.
Okay. What are the significant things of interest that you would like to point out to us between the two assessments?
When I evaluated him in 2022, I was making some predictions about his ability to engage, to participate in programs or services that would help him grow and change in a positive direction. When I saw him this year in February, I had some data that showed me that he could, in fact, engage and grow in a positive direction. He made the educational gains. He worked in therapy voluntarily. He's working out in the jail. He's taking up chess. And he is more able to talk about his feelings and his issues and to be vulnerable. And I think he's learned that from his work with Lindsay Holt. He's matured. I mean, there's a big difference between 16 and 20. We all remember what it's like to be teenagers. He's still got additional maturation in terms of his brain development, but I could certainly see a difference.
How would you describe your interactions with him?
He has, on both occasions, he's been very polite, cooperative, engaged. The first time I saw him, I spent more than 10 hours with him. This time it was more than 4 hours. I already had a lot of data. I didn't have to spend as much time. He was honest on tests. A lot of the tests that I give have validity indicators that tell me whether people are exaggerating their problems or denying problems that they actually have. All of the tests I gave him in 2022 and now had valid results. So he was honest in answering questions. I couldn't have asked for better cooperation or participation in my evaluations.
Are there resources or learning opportunities in the Tennessee Department of Corrections that would be available to Jordan?
Yes.
Could you tell us what those are, what he could have access to?
So he already has his high school diploma. He can do additional academic-based education. He can have vocational training to develop trade skills, electrician, cooking, carpentry, construction. He can get jobs based on the skills that he develops. So he can work when he's in prison. There are recovery support groups, so 12-step type groups that he can participate in. There are religious and character building groups that he can voluntarily take part in. If, at some point he could be a mentor to younger inmates. So he can continue to improve, change in a positive direction, and mature, building on the foundation of what he's done when he was in the jail here.
So I think what I hear you saying is those are ways that he can continue to promote rehabilitation efforts
Yes.
while he's incarcerated. Okay. Dr. Smith, I'm going to hand you something. Yes, sir. Let me make sure. Dr. Smith, could you identify that for me, please?
Yes, this is a report that I prepared dated April 1st of 2026 that addresses my most recent evaluation, but also incorporates information from my previous evaluation.
Can you tell us specifically what your conclusion is as it relates to Jordan's ability for rehabilitation?
Yes, based on the data that I have about him, if he receives the services and programs and opportunities available to him in prison and continues to work on himself, then there's a high likelihood he can be rehabilitated in prison over decades. And if he has an opportunity for parole, he will have to prove to the parole board that he is rehabilitated.
So there are incentives for him to continue.
There are many incentives.
And Dr. Smith, lastly, before I get to this, would you make that an exhibit to your testimony, please, your report?
Yes.
That'll be filed
Uh,
5/20.
And Dr. Smith, finally, could you tell us what your expert opinion is regarding Jordan's ability for rehabilitation?
In my opinion, there's a very high likelihood that he can be rehabilitated in prison.
Thank you. Mr.
You're
Collins,
welcome.
I have some questions.
Just a few, ma'am, thank you. And as I get older, I don't remember as well, but are you the same lady that testified downstairs in the transfer hearing we had previously?
Yes.
If I recall correctly, ma'am, you talked about his risk of recidivism, is that right, at that time?
Yes.
And it was in the low to moderate range, is that right?
Yes.
And has that changed here today?
You're asking about risk for future violence.
Yes, ma'am, recidivism.
And I have not updated my risk assessment because it's not possible to do a risk assessment that would be valid decades down the road. So risk assessments have to be done in a time-sensitive way.
Yes, ma'am.
So the prediction from when he was 16 really was only good for about 6 months because youth change so much. And
Oh, that's just me pausing it, guys. Wait 1 second. I wanted to change something out for us. Okay, here we go. Oh, no. I did that wrong. Wait a minute. Here we go.
and the Tennessee Department of Corrections does risk assessments as part of the parole process. They do them internally.
Yes, ma'am. And I see that, I couldn't help but notice on the bottom of page 8, top of page 9, you are aware of some behavior issues Mr. Allen's had in the, during the time he's been incarcerated here in Greene County.
Yes,
He's also been incarcerated in other areas. I think you're aware of that, right? Just as, I think he was in Sevier County for just a while.
he was in Sevier County initially.
Just on this charge, not on anything else. He doesn't have a criminal record or
Right,
anything
yes.
like that. He was a juvenile when this happened.
Yes.
But you're aware of the behavior issues in the jail.
Yes, I reviewed 3 incident reports.
And that would have been during all this time he's trying to get talking to people.
That would have been in the period when he had been transferred from being in isolation because he was under the age of 18 to the general population. And I talked to him about those, and he said it was just really scary moving into the general population. And there were a few incidents in that early period, and he said he felt he had to kind of establish himself for safety. And that made sense to me. And so that was, I think that was 2024. And then last year he had an incident of mutual horseplay that with another inmate, and they were both written up for horseplay. And he hasn't had any incidents since then, at least to my knowledge.
You're aware of other more serious issues other than this horseplay. I won't go into the details, but you're aware of those when you made this report. Is that right?
Yes.
Okay, that's enough of that. Let me ask you this, man. And I hope I don't, I'm not trying to stretch my luck. I'm just asking. The judge will call me down if I'm asking something inappropriate. Then you educate me, because I don't know. Does the fact that he would come in here this week, years after this happened, while he's getting all this treatment, and essentially sit up there and maybe not be truthful, accuse his grandfather of doing something that he did, does that have any play as it relates to this report? Would that influence your report in any way?
Well, that's not something that I've evaluated, and I'm not here to excuse him. I'm here to talk about his ability to be rehabilitated as a 20-year-old over decades in prison. So I think he has work to do, and I think if he gets the help that he needs, he can be rehabilitated.
Fair to say we've all got work to do. I don't know of anybody that doesn't have a little work to do.
Yes.
I know I thank you for I appreciate you. Thank you.
Anything else from her?
No, sir.
She free to go?
Yes.
Thank you for being here. You're free to go. Call your next witness.
Sherry Allen?
Sherry?
Yes.
What you said right there. Get right up there. Get comfortable and speak up so we can hear you.
Hello. Would you state your name for me, please, ma'am?
Sherry Allen.
And your middle name is Jeanette, right?
Yes,
Sometimes you go by Nettie.
yes, ma'am.
Okay, I'm gonna try not to call you Nettie, but it comes out of my mouth before I know what I've done, okay? What is your relationship to Jordan Allen?
I'm his mother.
You're okay. You just take your time, okay? Miss Sherry, can you tell the jury where you work?
I work at the next door recovery center.
And what are your responsibilities there?
I'm a BHT. We take in people from the street that's in addiction and take them to classes, do classes with them and groups and stuff like that.
What does BHT stand for?
Behavioral health tech.
Okay, all right. Now, how did you come to get this position?
Well, I completed their program. It changed my life, so I waited the 2 years. I had to have 2 years of sobriety to work there, so I waited the 2 years and then I got a job there.
Okay. Now, you mentioned sobriety. You were in active drug use for quite a long time. Is that correct?
Yes, ma'am.
Okay, how long was it, if you recall?
Since I was 16.
And listen, I'm not supposed to ask a lady her age, but
How dare you know?
no.
46.
So 46. Okay. So when did you became sober? When? About 3 years ago?
Yes, ma'am.
Okay. So a very long time, a large portion of Jordan's life. Is that
ma'am.
right? Okay. Are you clean and sober today?
Yes, ma'am.
You are still clean and sober. It's been over 3 years.
Been almost 3 years.
Okay. And you are here today. You're going to talk to me about Jordan. Is that right?
Yes, ma'am.
You and I have had some hard conversations,
Yes, ma'am.
but we're going to talk about your parenting and we're going to talk about some things that are hard to hear. Is that
Yes,
right?
ma'am.
Okay. They're hard truths for you.
Yes, ma'am.
All right. If you need a break, you just let me know, okay? Tell me about your pregnancy. You had a difficult time getting pregnant. Is that right?
Yes, ma'am.
Okay.
It took me 8 years. Me and his dad was married 8 years before we had him.
Did you smoke cigarettes while you were pregnant?
Yes, ma'am. And marijuana.
And marijuana? Did you have any complications in your pregnancy?
Yes, ma'am. I had him at 6 months, 28 weeks.
So he,
I found out when I was 4.5 months and turned around and had him at 28 weeks.
okay. So he was born prematurely.
Yes, ma'am. He weighed 2 pounds, 10 ounces.
Okay. He had a difficult start from day one.
Yes, ma'am.
Is that right?
Yes, ma'am.
Okay. How long did he stay? Well, let me ask you this first. Did he go to the NICU?
Yes, ma'am.
How long did he stay there?
Well, when they're born premature like that, they start out at like a negative number. So whatever. So they said he would be in there till he at least hit the zeros. But he was only in there for a month and 6 days. Like he was
Okay.
a fighter.
So he kind of progressed nicely then.
Yes, ma'am.
All right. Miss Allen, I'm going to pass you a piece of paper. Can you tell me what that is, please?
It's his birth certificate.
When was he born?
February 2nd of 2006.
Okay. And would you please make that an exhibit to your testimony?
Yes, ma'am.
Make that exhibit 521, birth certificate.
Were you and Jordan's father together at this time
When
Jordan
yes, ma'am.
was born?
Yes, ma'am.
Okay. Describe the living arrangements that you had when Jordan was a baby.
When he was a baby, we was renting a house. We had our own house until he was probably about 3.
Okay.
And that's when the addiction started.
That's when it started.
Yeah.
So then when he was a small child, tell us what he lived in from that point forward when your addiction started.
We went back and forth to mom and dad's, his dad's, his brothers. So just kind of back and forth between those places.
He didn't really have a stable place, is what it
No.
sounds like. Okay. And did you and his father change residences multiple times as well? Or did you stay in the same spot?
What do you mean, before we had him?
No, during when the addiction.
Yeah, it was
happening.
all of us going.
Okay, it was all of you who went to various
Yes, ma'am.
households. Okay. So you had just short stays places. He didn't really have a place that he could call home. Is that's fair? Okay.
Fair.
Once he was in school, did he continue to change residence? Okay. And he did that multiple times.
Yes, ma'am.
Did he have numerous school transfers beginning in kindergarten?
Yes, ma'am.
Okay. So did he go to multiple schools his first year in kindergarten?
I think in kindergarten he was only in one, but in the first he went back and forth. I think.
Well, let me give you something here. I gotta show. I'm gonna show you something, Miss Allen, okay? If you could look at it and tell me what that is.
That's his school transcripts, I guess.
Okay. You kind of helped make that chart, right? Gave us some info for it.
Mm-hmm.
Okay.
So it does say that he went to 2 different places in
In
kindergarten.
kindergarten. Okay. I'd like you to make that an exhibit to your testimony, if you would,
Yes,
please.
ma'am.
It's an educational chart. It's like a flow chart of the schools that he went to, Judge.
Okay. Exhibit 522. School chart.
So all of these changes, please, Tracy, thank you. All of these changes that happened, did that have to do with custody changes?
Some of it towards the end.
Okay. So some of it, when you were changing houses, it was just instability.
Mhm.
Okay. But other times there were some custody
Yes, ma'am.
changes. Okay. Whose custody did he go into when those changes were happening? Do you know?
When me and his dad split up, we was doing 2 weeks with me, 2 weeks with him.
Okay. And that was, you said, when Jordan was about 8, I think, did you say?
I think between 6 and I'm not
6 and
sure,
8.
yeah.
Okay. And can you just look at that chart and just, it may be gone, it's okay.
Mhm.
Do you have an estimate of how many schools he went to?
My guess would be about 12 to 15, it looked like,
Okay.
maybe.
And sometimes you count them twice if he went back to a school, if he had been there and left and gone back. Okay. All right. Now, do you think that that had any kind of impact on Jordan being able to establish relationships with people?
Absolutely.
Well, now tell me why you think that.
Well, I mean, it would be hard to build any kind of relationship, you know, if you're not there that long or move around. It's hard to be the new guy.
Okay. Did Jordan continue to live with you after you and his father separated? It was half and half.
Was,
right?
it was half, half and half.
Okay. Did he go to live with your parents at any point in time when
Yes,
you
ma'am.
separated?
Yes,
Okay, so
ma'am.
he had that change in there too.
Mhm.
How long did he live with your parents the first time?
I think it was probably about a year and a half, maybe close to 2 years.
Okay. Did you and his father have contact with him during that time, or
Yeah, I did.
you did?
Yeah.
Okay. You had contact, he just didn't live with you?
Right.
Okay. And was Jordan sometime returned to you, to your custody? Did he come back to live with you?
Yes.
At what age was he? Do you know?
I think about 10, I think
Okay.
10 or 11 maybe.
10 or 11?
Yeah.
Was anybody else living with you then?
Yes.
Who was living with you?
Matthew Rogers.
And was he your boyfriend?
Yes, ma'am.
Okay. Did the two of you use drugs in the home?
Yes, ma'am.
Was Jordan exposed to the drug use in the home?
Yes, ma'am.
Did he see you use drugs in the home?
I try to not use it in front of him. I do know he walked in the bedroom a couple of times, but I'm well aware now that he definitely knew what was going on. You know what I mean?
Okay. Were there any drug-related activities that went on in your home?
Yes, ma'am.
Tell me about those.
I mean, we just had different people coming in and out.
Were they coming in and out to buy things, to use things? What was happening?
Both.
Okay. So you had people, did Jordan know these people?
I mean, he did get to know them, yeah.
Okay.
But no, not in the beginning.
Okay. And they would come and buy or come and use with you, is that correct?
Yes, ma'am.
Did, now this is going to be a tough one, okay? Did your drug use take priority over you being a parent to Jordan?
Yes, ma'am.
It did for a long time, is that right?
Yes, ma'am.
Do you regret that?
Absolutely.
You think it impacted Jordan negatively?
Absolutely.
Was there domestic violence in your home?
Yes, ma'am.
Did Jordan see that domestic violence?
Yes, ma'am.
And was he ever a victim of domestic violence in your home?
No, I never would have allowed that. I would have allowed that. I do think there was a couple of things that happened when I was going to work that I found out about, but I would have always took it for Jordan.
Did he see you in the position of being a victim of domestic violence?
Yes, ma'am.
How often did that occur?
Pretty much every day.
So he was living in a house where there was drug use and violence every day.
Yes, ma'am.
Okay. Your own admission, you said, was there much parenting happening?
I mean, no, I tried, but
Okay. How long did this continue, Sherry? How long did he live in a house with drug use and domestic violence?
it was a few years, and then I took him to mom and dad's.
Is that why it stopped? Is that,
Yeah.
that the reason that it stopped? You took him?
Yes.
Okay. Were you charged with any kind of criminal charges, any drug charges as a result of all of this?
Yes, ma'am.
Were you convicted?
Yes, ma'am.
And what was your conviction?
8 years.
Do you remember what you were convicted of?
Possession of a Schedule II, possession of marijuana,
Okay.
maintaining your dwelling, paraphernalia,
And a Schedule II, can you tell us what that is?
methamphetamines.
Okay. So So you went to prison.
Yes, ma'am.
Where did Jordan go then, Sherry?
He was with his dad.
Okay.
His dad had came during this time and taken off with him. So he was with his dad at the time when I went to prison.
Okay. While he was living with his father, were you aware of whether or not he was diagnosed with ADHD?
I did find that out. I do know that when he was younger that they had talked to us about ADHD, and I just kind of shut it down. I didn't really believe in that medicine.
So when he was younger, they advised you to get him some treatment and you did not. Is that what you're saying? Okay. Did anybody give him any treatment for the ADHD at any point?
Not when he was with me, but I did hear when he was with Jennifer and Mike.
Okay. Okay. Now, just for clarification, Jennifer was his dad's
Aunt.
girlfriend, but aunt,
Aunt,
right?
yeah.
Okay. All right.
Yeah.
Were you ever made aware that it was recommended for Jordan to undergo a mental health assessment?
No, I don't think so.
Were you aware whether or not it was recommended for Jordan to see a neurosurgeon at Vanderbilt over some health problems?
I did find that out later, yes.
Did he receive those services?
I don't believe so.
Did you have contact with Jordan when he lived with his dad?
I did not.
So how long did that go, Sherry, that you didn't have contact with him?
It was about at least 2.5 years. I was already in prison before he brought him and dropped him off with Mom and Dad.
Tell me why. Tell me why you didn't have contact with him.
I didn't know where they was.
Okay. How long did he live with his father?
I think it was about 2.5 to 3 years. I'm not exactly sure.
And where did he go after living with his father?
It's when his dad brought him to Mom and Dad's and dropped him off.
Okay, tell me about that. What was the situation?
I was in prison.
You were in prison. His dad, you said, dropped him off at
Yeah, that's what I was told, yeah.
Bill and Sherry's, right? Okay,
I got a letter one day from Jordan and found out that he was back home.
okay. Is it fair to say that his dad didn't explain he was going to be living there?
I don't believe he did, no.
Okay. Is it fair to say he just dropped him off there?
Yes, ma'am.
Didn't come back, and he's still not come back. Is that right?
That is correct.
All right. So Jordan was there, not his choice, not having his mom or his dad. Okay. How old was Jordan about the time he got dropped off there?
About 12, I think.
Okay. Getting up there a little bit, huh?
Yeah.
Okay. Do you know whether or not Jordan knew his father wasn't going to come back?
No, I think Jordan always thought his dad would come back, or he at least hoped he would.
And I think you said this, he didn't get his ADHD medication with Bill and Sherry either. Is that right?
Not that I'm aware of, no.
Oh, okay. Just making sure. He got it with Jennifer, but nobody else.
That's what I was, yeah.
Okay. Did you reestablish contact with Jordan after he got dropped off at Bill and Sherry's?
Well, as much as I could, I was locked up.
Okay. What did your contact look like?
Talk on the phone. Maybe
Did you
later.
write letters or something? Okay. How often did you do that, Sherry?
We talked maybe 2 or 3 times a month, maybe a letter or two.
Okay. I mean, it sounds like that was pretty limited
It was.
contact, right?
Mhm.
Okay. Did Jordan ever express to you how badly he wanted you and his father?
Yes, ma'am.
Tell me what he said.
He said he didn't care if we lived in a tent. He just wanted to be with me.
Now, Sherry, this one is going to sting a little bit, okay? It hurts my heart a little bit, to tell you the truth. After you were paroled, did you go back to Jordan?
I had to go to a halfway house.
So you didn't?
No.
You did not?
Mhm.
Okay. Did Jordan think, hope that you were coming back and it didn't happen?
I mean, I'm sure he was hoping I had to go to the halfway house.
But, I mean, he's
But
just,
he probably, yes.
he's just a kid, right?
Yeah.
All right, so he didn't really understand
Right.
that part. Okay. What about any kind of letters or phone calls when you were in the halfway house? Did you keep in contact with Jordan?
I called probably not as often as I should.
How often did you call Sherry?
I mean, I don't know, 2 or 3 times a week.
Okay. So sporadic contact?
Yes, ma'am.
Okay. Did you have any physical contact with Jordan after you were released?
When I would get a pass, I would take it. I only got a pass. You only get very limited passes from the halfway house. They did allow me to have 48 hours because it was a drive. So it was very limited.
So you were in prison for 8 years.
No. Only
And then-
done.
Oh, that's right.
Yeah.
What'd you do? That's right. What'd you do?
I done like 3.5 and then got out.
Okay, so you were in prison 3.5 years and came out, right?
Mhm.
How long were you in the halfway house?
I was in the halfway house for 15 months.
Okay, so that's what, 4.5 to round it off?
I was there 19 months. I'm sorry.
Okay. Now, how many times did you have physical contact with your child during that time?
We could take only 1 pass every 3 months, so it wasn't very many.
Okay.
Then I became a house lead at the halfway house. So once I became a house lead, then I wasn't allowed to take even that many visits.
Did you violate your terms of parole at some point?
Eventually, yes,
How long were you out before you violated and went back to prison?
3 years.
Okay. Why did you go back?
I relapsed
Let's be honest, Sherry, on what?
on meth.
After you returned to prison, did Jordan continue to contact you and express his desires to have you in his life?
Yes, ma'am.
He wanted you to be a parent, but you weren't. Is that right?
That's correct.
He wanted you to protect him, but you didn't.
That's correct.
And he didn't care what he lived in. He just wanted to live in that with you,
That is correct.
but he didn't get that.
He did not.
Okay. You agree with me that, oh, those are like basic needs. It's kind of like sleep and water, you know? Okay. I'm sorry, did you want to say something? Okay, I didn't want to cut you off, Sherry. What was your relationship like with Jordan? Like, did it change after you went back to prison?
No. Stayed the same.
Stayed the same? Does that make you sad?
Yeah.
Why does it make you sad, Sherry?
Well, when you're in jail and prison, you always tell yourself you're gonna make up for lost birthdays and lost time and all that. And I never made it back out to change any of those things.
Regret that pretty deeply.
Absolutely.
Do you feel like you being incarcerated negatively impacted Jordan's life?
Yes, ma'am.
I'm going to ask you this again, all right? Honestly, do you feel like you ever nurtured him? No. Do you feel like you ever gave him what a parent should give a child? What are your regrets, Sherry, that relate to Jordan's life?
Yeah, everything.
Think his life could have been different had you been different?
Yeah, absolutely.
Do you feel any responsibility for his situation?
Yes, ma'am.
Tell me why you feel responsible.
Because I need to show him nothing no different or no better.
We agreed when we started, we were going to talk about some hard stuff, right?
Yep.
So as you sit here today, you are Jordan's mom, you are clean, and you are sober. Tell me, did you fail him?
Yes, I did.
Sherry, you've had some guts today. You've said some things that are hard. Do you want to share anything else with the jury?
I don't know, maybe just show him more mercy than I did, you know? He has an opportunity to still have some sort of life at some point. He deserves that.
Thank you, Sherry. If you'll just hang on, Mr. Collins might have a question.
Collins, you got some questions?
Yeah, I got just a few, please, if you'll allow me. I don't want to lose sight of, you are Bill and Sherry's daughter, is that right?
Yes, sir.
Bill's your daddy.
Yep.
And you and I talked on the phone, you may not remember, I think you were still in jail. I had to get a hold of you to let you know what was taking place,
Yes, sir.
or if you recall that.
Yeah.
We, of course you failed him. That's not, and I'm sorry. You, but you're Jesse's mama too, ain't you, ma'am?
Yes, sir.
Ma'am, when did you go to jail? We know Jordan had been up there, about 3 years before this happened?
What?
Jordan had been with his mama
Yes.
and papa about 3 years.
Yes.
Ma'am, do you recall what year it was you went to jail?
2015, I believe.
And you got an 8-year sentence? Okay. And you only served, so you got out, roughly 18?
June 2018.
And you spent, well, if you spent 2 years in the halfway house, you got out in 20, roughly. I'm just trying to put the
Yeah.
dates together as, you know, just trying to connect it to when this happened. But you were back in jail when this happened, right?
Yes, sir.
Okay. So once you get out of the halfway house, it didn't work out. You end up going back.
Mhm.
Okay. I just, are you close with your father?
I was.
You was, you're not now?
Well, I mean, you know.
Do you
Tore a
think
family
you're,
apart, right?
I'm sorry, ma'am.
I said something like this will tear a family apart, right?
Well, your daddy didn't do it. I don't want to lose sight. You're Jesse's mama too.
You're right. I am Jesse's mama too.
And it just seems like you didn't make a difference in them, did you?
I love both my kids.
Of course you did. But you're asking them to give Jordan a chance now. Jesse ain't getting it.
You're right. You're right.
I just don't want to lose sight of the fact that you've got two
And I
kids.
don't want you to lose sight that I had two kids as well.
Yeah,
One's
I
not
do.
here and the other one is.
I want
And I'm
to
showing up for
support
him now like I never did before, sir. Thank you.
Just you ain't gonna get to show up for Jesse anymore.
No, sir, you're right. Thanks for pointing that out.
Well, I've got to. I've got to. You, this is hard on all of us. You said it stings. You don't think it stings us? Some of us are closer to
I
our,
never said it stings.
as close to our
Those words didn't come out of
grandkids
my
as we
mouth.
are kids. Nobody
you.
wants to be here. They didn't know any of them prior to Monday probably, and it stings for them. They've got an awesome responsibility weighing on them.
Yes, sir.
A lot of kids, you were probably in jail with a lot of moms, wouldn't you?
Yes, sir.
A lot of moms, kids. Just because the kids had it rough, that don't excuse taking a hammer to somebody's head, does it? And then does that excuse not just that, but then trying to blame it on your papa, the only daddy he's ever had?
Yep, that's your side.
I'm sorry, I couldn't.
I said, that's your side, sir.
Nothing else? Can she come down? All right, you can come down. Fans, call your next witness.
Judge Mike Garland, and he was not sworn.
Mike Garland.
Yes.
Garland, raise your right hand, be sworn. You solemnly swear from testimony you give me the truth, the whole truth, just the truth, so help you God. I do. I want you to step right there, have a seat right there, scoot up, get comfortable, pick up swing hands.
Hello, Mr. Garland.
Hello,
How are you?
doing good.
Seeing each other in a different courtroom. is kinda weird.
Absolutely.
Would you state your name, please, sir?
Mike Garland,
Mr. Garland, could you tell a jury where you work, please?
Greene County School System at Glenwood Educational Center.
How long have you taught?
31 years.
Have you taught that whole time, or did you move into administration?
Been in administration for approximately 16 years, I think.
Okay. In administration at Glenwood, is that a little bit different than in administration in a normal school setting?
It is. We see a lot more behaviors and different types of behaviors.
You're probably in closer contact with the kids just because of smaller numbers. Is that right?
Absolutely.
Okay.
Yes.
How many children do you think you've taught over all those years?
I wouldn't have any idea. Several,
Thousands, huh?
I'm sure.
Have you always taught children that had any behavioral issues? Or did you kind of start out in like a regular classroom?
I started out as an agriculture teacher, did that for about 15 years, ended up principal of Chucky Doak High School for 6 years, and then went to the educational center after that.
Okay.
And been there approximately 10 years, I think,
Okay,
9 to 10,
if we're counting.
if we're counting.
Let's not count. That makes us old. Mr. Garland, do you know Jordan Allen?
I do.
Can you tell us how you know Jordan Allen?
Jordan was sent to ABIC in October of 21. I think we did an intake on October the 27th, and he started with us on October the 29th of 21.
Okay, just so we're clear, I know Mr. Woolsey and some other people will know what this means, but for anybody who doesn't know what ABIC is, can you explain that?
It is the Greene County Alternative School.
So if we have truancy or grade problems or behavioral problems or whatever, do they go there?
Not necessarily truancy.
Okay.
Anyone that's had any behavior problems, or if they're coming out of a facility, sometimes we'll do a 10-day observation with us as a step down before they go to the regular school environment.
Okay. How are Jordan's grades? Do you recall?
I don't have his grades previous to coming from us, but I think they were a lot lower then than they was with us. Normally students will do better with us because it's a smaller environment. We have a teacher and a teacher's assistant in every classroom. They get a lot more one-on-one help, and they work at their own pace in a program we call Odyssey Wear. So I did get a glimpse of his school records last time I was here. When he was at Chucky Doak, and they were quite a bit lower than they was with us, but he was passing everything once he was with us.
So in that structured environment, he was making some positive progress.
Yes, he was doing
Okay.
very well with us.
Can you tell us what his behavior was like in your school?
In my building, he had some previous things at Chucky Doak, of course, to get sent to us, but when he was in our building, Jordan had excellent behavior with us, short of, I think we had 3 incidents One was that a girl was able to get a vape in, and she handed it to him one day, and he hit the vape. I think actually I talked to him the Friday before all this happened, had him in my office and had a conversation with him about that, and added 10 days of ABIC time. It was a nicotine vape. He admitted to taking the vape and hitting the vape. The only other issues we had with Jordan at all was, I think he was with us a little bit over 6 months. The only other issues we had with him was there was one day he was putting a coat up over his head, and the teacher had to tell him several times to keep the coat off of his head. And I think he was caught one time on a YouTube site instead of being on Odyssey Wear.
Okay.
But other than that, he was really great in our building.
Okay. Do you have an opinion on how he handled the structure of your program?
I mean, the biggest issue with Jordan was just him trying to get there. There was transportation issues. I think he missed 18 days in the beginning, just trying to figure out transportation because they don't offer transportation to the alternative school. I think the family was down to one vehicle, and I think the grandfather, I think Bill had to take that to work. But once they got the other car repaired, I think his grandmother was bringing him pretty much most days, and his grandfather brought him a day or two also. But as far as in the building, I mean, I can't remember ever having any issues with Jordan other than the three things I just mentioned. And we even, we only let a handful of students go into other rooms and read to other kids in other programs. And Jordan was one of those that we allowed to go in. And I mean, he just seemed like he enjoyed it. And the young kids enjoyed him.
You said he seemed like he enjoyed it. Did he seem like he enjoyed the little kids?
I mean, yes, that's who we had him to go into we've got some other programs. The BEST program is one of them, where we put a lot of emotional disturbed students that have, issues at school, and we're trying to work through helping them to overcome those issues. And that was one of the classrooms that he went into, as well as a few other students in his class, and read to kids, and it went very well. They seemed to be a great rapport between him and the other students.
Was he always appropriate with the other students?
To my knowledge, he always was.
And was he kind to the little kids?
As far as I know, I never seen any issue at all. And like I said, he seemed to enjoy it, and the kids seemed to enjoy it.
Is it safe to say he was well liked?
Yes, very much so. Not only among the other students, but he was also well liked among the teachers. I think any teacher in our building would say they're shocked at the least with this situation. Based on the Jordan that we knew at school.
I was going to ask you what your overall opinion of Jordan was when he was there.
Actually, the Friday that I pulled Jordan in to talk to him about the vape was that Friday before this weekend. And, Jordan, I said, Jordan, why did you do that? And he said, Mr. Garland, it was just dumb, but I did it. And I sat there and just talked with Jordan for probably 30 minutes afterwards. And he was very likable. He was always polite. He mostly followed the rules other than them three situations. He wasn't an issue behavior-wise for us. And I will say they're very closely watched and very closely supervised in our building. But other than those three issues, we never had any negativity from Jordan at all.
Did he go out of his way to make younger kids feel comfortable, high-five them or anything in the halls? Did he do anything like that?
He did. Miss Stacy was just commenting that the other day, how when he would go down the hall that he would wave at the little kids and they would wave at him, and there was just a good rapport there. And he wasn't around the little kids much at all, the younger kids, because he was in high school ABIC with just 9th through 12th, but just the ones he read to in the classroom. Those kids that sort of knew him from that is the ones that he would interact with going up and down the halls, and it was always positive.
Was he on track to finish school and earn his diploma?
He was actually, the best I remember, he was behind. We had him, I think he was a sophomore when he was up with us, and he had failed several classes as a freshman, if I remember correctly. But he did, I think he recovered them through credit recovery and recovered some classes while he was with us on Odyssey Wear.
Do you happen to know whether or not he earned his diploma? Anybody make you aware?
To my knowledge, he did. He graduated with 22 credits. I think the guidance counselor at Chucky Doak High School, Shanna, went and worked with him some, and he was able to finish up with 22 credits and graduate. He got a regular diploma.
She went and worked with him while he was incarcerated? Is
I
that
think,
correct?
to my knowledge, yes.
Okay. Is that his transcript, Mr. Garland?
It is.
Would you mind to make that an exhibit to your testimony, please, sir?
Absolutely.
Thank you so much.
You're welcome.
Please be filed as exhibit 523.
Let me ask your opinion on this. What does that say to you that it doesn't have to be, Tracy? What does that say to you, Mr. Garland, that Jordan chose to continue pursuing his diploma even when incarcerated?
I mean, I have to say I was surprised, but that, he would focus on that while incarcerated. But at the same time, I mean, it doesn't surprise me with the behavior we've seen out of Jordan. I mean, he always done what we ask of him. And in the classroom, I mean, he was always on task and did what we asked him to do. And I know Miss Shanna from Chucky Doak is excellent at trying to motivate a student to work on their diploma. So I was surprised, but I wasn't.
Mr. Garland, I thank you so much for being here. Mr. Collins may have some questions.
Thank you.
Just a few, sir. Mr. Garland, thank you for being here.
You're welcome.
Sir, were you ever aware of Jordan running off or anything from school or laying out of school?
I mean, the only issue that I can remember without going through his attendance was just those days that he missed up front with us. Seems like I did hear that he had run off at least once, but I'm not sure that was when he was in our building or if it was before he came to us. But I think the 18 days that we had to add back for ABEC or alternative school time, I think that was due to the transportation issues.
I think the time you're referring to, that was with one of the Broadwaters, as I recall. Is that true? Based on what you know.
I'm not sure.
Okay, that's
I
fine.
just know there was transportation issues.
And he didn't lash out or anything like that at your school?
Never seen any temper or lashing out or anything while in our building that I'm aware of.
Always nice to everyone.
Absolutely. Honestly, I mean, we thought highly of Jordan, and I knew he had been through a lot and everything, and I guess we just had a big heart for Jordan, and he seemed to have for us too.
You never had an issue out of Bill or Sherry, did you?
No, absolutely not. I had a meeting with both of them and seen them, on a regular basis, and they were always great with faculty and staff.
Did they seem like they were doing the best they could?
Yeah, I mean, to my knowledge.
To your knowledge. I'm not
yes.
trying to put you on the spot, sir. I'm just trying to build a record and make sure we want them to have as much information about his entire background as we can for whatever decisions.
Yes, to my knowledge, anytime we had to call them, they were supportive of us. And anytime, I remember we met with Bill a few times. I'm not sure if we had any meetings with Sherry, but we seen her in the car line and, talked to her and everything. And I don't remember any issues at all.
In fact, sounds like you were floored when this happened.
Yes.
You didn't have, okay. Thank you.
Thank you.
Anything else from him?
No, sir.
Be free to go?
Yes, sir.
Free to go. Thank you. for being
Thank
here.
you.
Any other witness?
No, sir.
Rest?
Yes,
Bench rest. Time to take the jury out for a break. We'll come back in. I'll read this final charge to you and you'll go deliberate. All right. Jury out. Be out by 15 to 4. Take them out. 15 to 4. We'll come back. I do want to go ahead and make that jury charge from the trial. Just make him an exhibit. Get exhibit.
this kind of almost feels like we're going through the DP phase with, I didn't know they did all of this in regard. I didn't know the jury decides it, but something new all the time. Dang, I think the last Tennessee case that we had, they did it there. Like the judge did it.
Members of the jury, I promise you, we don't like to have to do this. Don't want to have to do this. It is tough. But all of us, I've got kids. They're grown now. He's got grandkids. This is about the most awesome responsibility that anybody could be asked to bear. I mean, you all got one. And I said earlier that this is your community, and you're gonna, the only thing I would, as far as the aggravating factors, these deaths were, I submit to you that we have proven those two aggravating factors, and then you have to decide if what they put on this afternoon, if their mitigating evidence outweigh those, and that's for you to decide. The only thing I would ask you to remember, I'm sorry that Jordan has been raised. He's had an unbelievably tough life. I can see that. But a lot of people have tough lives. And you can't do that. Jesse didn't have any more life. Sherry doesn't have any more life, and for all purposes, Bill Cole doesn't either. And he had a chance. He's had every chance. He had nothing to say when they asked him in that statement that y'all have heard a couple of times now. Do you have anything to say to you, Papa? And then he comes in here 4 years later, and he still points the finger. I said that to say there's just no remorse. There's not many things. Very few circumstances where the law, honestly, where the law allows a juvenile tried as an adult to be given a penalty of life without parole. If this isn't it, then I don't know what is. I think we should just throw away the book. You've got a 7-year-old little boy out playing with his little toy phone. And he beats that kid. And his mama, the only mama the boys ever had, to amount to anything. And to beat her eyes, he hit her so hard, her eyes were black. I appreciate the service that you've performed this week. And we've just tried to lay out, you just decide if it's enough for the ultimate, you decide if it's enough for life without. Whatever decision you make, we absolutely have the utmost respect for. As I said, this is your community. I wasn't raised here, but I've been here long enough now. It's mine. I've been here now closer to 20 years than I have 10. I just ask you, if you need to look again, take a look. State has proven all of those. State's proven enough. What you have to decide is the fact that is having a rough life enough to overcome that. A lot of people have rough lives. Not everybody takes a hammer to a 7-year-old's head. Thank you.
All right, Mr. Albert.
think I began by saying I was kind of floored that I would be using skills from juvenile court in a criminal court case. As a matter of fact, I had something personal happen to me that caused me to step away from juvenile court. Juvenile court is really the love of my life, to tell you the truth. And I'm gonna tell you what the truth is. Jordan Allen is just like every single one of those kids I have ever dealt with. I'm not giving you that as an excuse, and I'm not trying to justify that. I'm telling you, though, that there is more to him than what has happened today, what has been discussed today, this past week. I hope that through the testimony, you've been able to gain a little bit of insight into who Jordan is as a person. I told you were going to hear about it from several people, and they were going to tell you what I already know. Well, here's what I know. Jordan is good, and Jordan is kind in a whole lot of ways. And I'm not afraid to tell you that I love Jordan as if he were my own. You heard from Jessica Rickard, who works at the detention center, and she told you about all the things that Jordan has been doing to rehabilitate while he's been incarcerated. And she didn't just give us 4 or 5 or 12 certificates. She gave us 20 that he voluntarily did. And while he was there, he got his high school diploma. I mean, most people would have just quit. But he had enough in him to continue and to try to make himself better. Not only that, he took some classes about self-regulation, and he has worked countlessly with the forensic social worker for 4 years and made himself uncomfortable. It's uncomfortable to have to talk about things that happen to you. It's uncomfortable to have to talk about trauma and vulnerabilities. And it's uncomfortable to have to admit that the people who are supposed to love you more than anything don't. And it's probably uncomfortable if you're Jordan, that you've got an attorney like me who comes down and tells you every day I see you, to remember that you are worth something. And remember you are valuable. But he does that now, and he talks about his emotions because he spent time with the forensic social worker who's taught him how to deal with it. The Jordan Allen that was in existence when this crime committed is not the same Jordan Allen that is sitting over here behind me. This kid had never had any structure, and I'm gonna let you in on a secret because Jordan told me that I could. Jordan has expressed that he never had family, and he never had anybody he cared about until we got assigned to his case. I'm telling you, this is a different kid. You also heard from Dr. Smith. You heard about her opinion. She's a forensic psychologist who evaluated him. We qualified her as an expert, and she is of the opinion that Jordan is highly likely to be rehabilitated, and he no longer poses a risk if he receives the treatment that she recommends. She told you that those treatment options were available while he is going to be in prison. You heard from Mr. Garland. I like Mr. Garland. He's a nice guy. And it's interesting that he talked about how Jordan was with the small kids. Jordan would tell you he was that way with them because he wanted to give them something he'd never gotten. He'd never been nurtured, and he wanted to give that to them. And then you heard from his mother, and that was pretty grueling, I guess, if you're Miss Sherry Allen. And she just absolutely admits that she felt him in every single way. This child grew up without a mother or a father, and that's all he ever wanted. All those years in juvenile court, even kids who get adopted, you know what they want to do? As soon as they turn 18, they want to go back to their moms and dads. That's all they want. Innately, that's what we want as humans. Well, unfortunately, He didn't get that opportunity with his mom or his dad. Interestingly enough, you'll notice that his father wasn't here. Michael Allen, he's not here. He abandoned Jordan. He abandoned him in his life at every part of his life when he needed him. And he did it again during this trial. I submit to you that that Jordan has been failed by many different individuals. He was even failed by DCS and youth villages, if you want me to be honest. But I started out by saying this: we are all more than the worst day of our lives. We're all more than the worst thing that we did. He's a child to me, okay? So I refer to him as a child. He is going to spend decades in prison. It's going to happen. You found him guilty, and that's what's going to happen. I'm telling you that because he will get a punishment. I'm asking you to be okay with that as a punishment and be okay with giving him an opportunity for parole, giving him an opportunity to come out, do something, and prove to himself that he is worth something. Because every time I said that to him, I meant that.
All right, you think we're gonna need to order dinners for y'all? It's 4:00 now. I can get them start working on that. We need a dinner. You wanna wait a little while, see if we need dinner? We'll wait just a little long. All right, in council 1 and 2, first degree murder, fixing punishment of life imprisonment or life imprisonment without possibility of parole. Members of the jury, you have now found the defendant guilty beyond a reasonable doubt of murder in the first degree as charged in count 1 and 2 in the indictments. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years in such sentence. The defendant who receives a sentence for imprisonment for life without parole shall never be never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond the reasonable doubt and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in the case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts from the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law, but moral certainty is required, and this certainty is required as every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the sentence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or any physical effects of the victim's death on members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant and not an emotional response to the evidence. Victim impact evidence is not the same as aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. The introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence and determine the appropriateness of the sentence only if you have first find that the existence of one or more of the aggravated circumstances has been proved beyond a reasonable doubt by the evidence independent from the victim impact evidence. Statutory aggravated circumstances. Tennessee law provides that no sentence for life, imprisonment for life without the possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. Number one, the murder was especially heinous, atrocious, or cruel, and it involves torture or serious physical abuse beyond that necessary to produce death. Number two, the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. You are instructed that the word heinous means grossly wicked or reprehensible, abominable, audacious, vile, atrocious means extremely evil, or cruel, monstrous, exceptionally bad, abominable. Cruel means disposed to inflict pain or suffering, causing suffering, painful. Torture means the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without the possibility of parole will be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but not limited to the following. Number one, the defendant has no significant history of prior criminal activity. Number two, the youth or advanced age of the defendant at the time of the crime. Number three, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record, or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstances. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Expert witness. During the trial, you have heard the expert testimony of Dr. Catherine Smith, who was described to us as an expert in the field of forensic psychology. The rules of evidence provide that scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue. A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state her opinions concerning such matters and give reasons for her testimony. In giving her opinion, Dr. Catherine Smith testified she took into consideration certain statements made by the persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied on as proof of the truth of the matter asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend upon your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. In counts 1 and 2, verdict, life imprisonment, or life imprisonment without the possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict on the enclosed form attached here to and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without the possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without the possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravated circumstance or circumstances proved by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. It says here listed statutory aggravating circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without the possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. Take the case, consider all the evidence fairly and partially. Complete one of the two forms and report your verdict to the court. Count number 1. Punishment of imprisonment for life. We, the jury, unanimously determine that no statutory aggravated circumstance has been proven by the state beyond a reasonable doubt. We, the jury, therefore find the sentence shall be imprisonment for life, signed by the foreperson, all the jurors, and dated. Or verdict form, count number 1. Punishment for imprisonment for life without the possibility of parole, or imprisonment for life. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstances or circumstances beyond a reasonable doubt. Here, list the statutory aggravating circumstances or circumstances so found, which must be limited to those enumerated for your consideration by the court in these instructions. Check one box. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without the possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life, signed by the foreperson, all the jurors, and dated. Count number 2. Punishment for imprisonment for life. We, the jury, unanimously determine that no statutory aggravating circumstance has been proved by the state beyond reasonable doubt. We, the jury, therefore find the sentence shall be imprisonment for life, signed by the foreperson, all the jurors, and dated. 4. Count number 2. Punishment of imprisonment for life without the possibility of parole or punishment for life. We, the jury, unanimously find the state has proven the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. Here, list the statutory aggravating circumstance or circumstances so found, which must be limited to those enumerated for your consideration by the court in these instructions. Check one box. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without the possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life, signed by the foreperson, all the jurors, and dated. All right, if you'll hand that to one of the members of the jury, we'll be in recess for your determination.
All right.
Yeah.
Okay, so just so y'all know, the jury has been back there. It looks like about an hour, a little bit over an hour, trying to decide this. What did you guys say? Let me see. I know I think I ended the poll earlier. So, okay, so wow, that was very close. Even though with parole, one, life without parole is really, really close. It's only losing by a little percentage. Wow, maybe one or two votes. And then 20%. Yeah, it's like almost, 26% said not really sure. Interesting. So I don't know if we need to stay here. I don't know how we gonna find out. That's what I can tell you. Right now, they still got their I guess kind of their feet up. It's just a black screen. As you can see, that's how I was able to tell how long the jury been out. I don't know if you got a chance to take the poll. Do we go back into our case in Atlanta? That jury is currently deliberating now, just so y'all know. Or I don't know if y'all want to sit here and watch read testimony, or are we not gonna watch any testimony, or are we gonna talk to each other later, or what we gonna do? You say never go to the hospital on Fridays and Saturday, you'll be there. He's so funny. Oh wow. Oh wow. Oh we. So I think that if we do go back into the Atlanta trial with the influencer, what we would do is I would just keep an eye out to see if the jury comes back with a verdict, a decision, and we wouldn't create a new room or anything for it. We would just show it. And yeah, I wouldn't start a new room and stuff. It's just not, it won't. That'll probably be too much stuff going on for me. Yeah, and the way they do it, it's just like, I don't know what they're doing, to be honest. Yeah, so here, I'm gonna play some tunes while I get everything set up, and then it looks like the Atlanta trial won. So we'll go over there and hang out and see how much we can complete before the verdict comes in on that one. I tell you, these juries is going, boy, but we sure getting in here and trying to get them done. Let me get this together. Y'all listen to some music. I was just trying to see what we had going on. Okay. Let me play some sweet sound. I'll take it to trial.
Junkie on the freeway, white claw in the brakes. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in chat. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the free. We the California's rolling deep on 9. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this. Yeah. SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far. She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah. Junkie, 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 junkie,
Susie, Shamrock, Shamrock,
junkie, 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 junkie,
Susie, Shamrock, Shamrock.
we the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. 4 names, 1 flame, can't remix this. When the live stream flickers on and Sweet Pea takes a stand, Lynn is already there, coffee in hand. She settles in for the long trials, the twists and the turns, with a loyal heart and steady eyes that never miss a word. She's a constant in the courtroom, a familiar shining face, always ready for the arguments, the tension and the pace. And when the evidence is messy or the stories sound untrue, she leans forward just a little. Lynn knows what to do, 'cause Lynn thinks everyone is guilty, every suspect, every tale. Melody Ferris guilty, she says without fail, but Dr. Rachel shakes her head. Sure, the son is to blame, still Lynn stands firm, her verdict stays the same. Oh, she brings the truth with a calm, steady light, and her presence is a comfort on every trial night. She listens with devotion through each objection and plea, through the cross-exams and pauses. She's where she needs to be, in the sea of courtroom chaos where tempers sometimes flare. Lynn remains unshaken, a voice of reason there. And though the chat may chatter and the theories may divide, Lynn's perspective never wavers. She speaks with honest pride. She keeps the room grounded when emotions run loose, a quiet force reminding us she's here to find the truth. Yes, Lynn thinks everyone is guilty, that's just her way. From the first opening statement to the end of the day, Dr. Rachel can argue the son's the one at fault, but Lynn won't budge. She's rendered her final thought. We appreciate her always for her loyalty and her proof, 'cause the church shines a little brighter when Lynn brings the truth.
Okay, so I do have a room ready for us. And like I said, if I'll have this up on my screen, long as they got it up. This way, if they do come back with a verdict or a decision, I guess I should say, we will just pause where we're at and we'll go over it. We'll view it over there. And then I'll just clip it out. Here is the link if you guys are joining for day 2. This will actually be day 2 of this other trial that we're going to be doing, the Atlanta influencer. So we will get through day 2 possibly, and yeah, we'll go into day 3 and see if we can get some of those closing statements before they decide whether he's guilty or not. Interesting. Let's see here. Okay, so that should, if you click on that, that will take you right over there. We'll get that started. And it may, I'm not sure if it'll redirect you guys over there. I did try to set it up so it redirect you, but we'll see. You'll see. If not, just click on the link. If not, it's on the page. All right, guys, I'll see you over there.